We're known for being a big case firm. We don't go to court with 10 files under our arms, as you will see with many other attorneys. We only take cases where the stakes are very high. We take cases that require extensive preparation. There is a large learning curve for you to go through to get prepared for our meeting. We want you to watch this video before we meet and discuss your case. The meeting will be more meaningful if you do this. Now, I would like to introduce you to the team members. I'm Patrick Clancy. I've been practicing law since 1974. I'm what is called a certified criminal law specialist. In the state of California, an attorney is not allowed to call himself a specialist unless you're certified by the California State Bar. Basically, what that means is I did so many trials, so many appeals, so many writs, obtained recommendations from judges, recommendations from district attorneys, and that then gives you the honor of taking a second bar exam, much harder than the first. The first bar exam had 14 subject matters. The criminal law specialist exam has 1 subject matter. My involvement in cases of false allegations of child abuse and child molestation predates the McMartin case, the infamous case in Los Angeles. Our law firm, as far as I am aware, is the only firm that deals exclusively with issues of false allegations in abuse cases. Dr. Larandos is a major member of our team. He's a psychologist and an expert witness. I met him decades ago on the East Coast when we were both attending training seminars together and giving them together. Over the years, it developed to where he was testifying in my cases as an expert witness. But since he is an expert, a psychologist and a lawyer, it eventually evolved that we started practicing law together. He's known nationally because of the work that he's published. He published cross-examining experts in the behavioral sciences. And he also published bench book in the behavioral sciences, psychiatry, psychology, and social work. What these 2 books do is train lawyers how to cross-examine experts. It also trains judges. That's what bench book means. In what you look for in terms of scientific reliability with so-called experts who are testifying in the behavioral sciences. Dr. Larandos heads up the science department of our team. He's been fighting junk science's use by the prosecution in abuse cases for decades. His knowledge and research are invaluable to our team and will be invaluable to you. The next person is our investigator. He is probably one of the central figures in our team because I believe that cases are won or lost based upon investigation. Harvey Shapiro was a member of the Riverside Sheriff's Department and was the head of their Crimes Against Persons unit, which is charged with investigating child molestation cases. The training that he has received is enormous. His resume is about 24 pages long. I think he's attended every major seminar ever given, and he's taught at most of these seminars. One of the things that I really like to point out is there is a gentleman named Dr. Stephen Ceci, who is one of the top suggestibility researchers in the world. Stephen Ceci does not like to testify. So what he does is he trains approximately 30 people a year by invitation only at Cornell. Harvey Shapiro was the only investigator that's ever been asked to come and train there. Since then, he's actually given training seminars at Cornell. In 1985, there was only about 1 line in the police training manual. It's called POST, Police Officers Standard of Training, having to do with false allegations. Several years ago, POST came out with a new training manual. Harvey Shapiro was the only defense investigator who was asked to be a consultant on this training manual. He's an expert in suggestibility research and one of the top investigators for the defense anywhere. Besides being a good investigator, he understands people. In representing you, he will use the same tactics that the police use. Let me give you an example. We had a client whose wife had divorced him, moved to Colorado, and every time he wanted visitation, he got accused of another act of molestation. She was living in this rich neighborhood with a very well-to-do doctor and felt that she could just throw lightning bolts down on her ex-husband every time he went for any visitation. One day, she woke up in her nice ritzy house in Denver and found that there was a gentleman named Harvey Shapiro going around door to door to all of her neighbors, finding out about the sex and drug habits of the doctor's new wife, which just happened to be part of the defense. The DA the next day got a phone call from the ex-wife telling the DA that they didn't want to go any further with the case, and the case ended up being dismissed. Harvey knows how to understand people and how to use that to our benefit. Another member of our team is Julie Schumer. Julie is a certified appellate law specialist. Again, the same thing as I said about criminal law specialists. She had to take a second bar examination after handling so many appeals, so many writs, recommendations from judges, and from her peers. Julie is highly unique. If you put Julie in front of a jury, I think she would pass out. She just does not want to be a public speaker in that sense. She's a Phi Beta Kappa English major from UCLA. She's a writer. She's a researcher. Normally, you would never meet someone like her unless you had lost your case and were up before the Supreme Court. However, we wanted to have our motions at the trial level to be of that top quality. They are so good that our motions are now copied throughout the state and are plagiarized all the time. Julie has a lot to do with the building of our motion banks. For those who don't know, motions are documents filed with the court that says that the prosecution has some evidence that should not come in, and here's why. And here's all the law and the cases having to do with that issue. Oh, and by the way, we have some evidence that should come in. Here's the case law and statutes which explain why it should be allowed in. Julie, with her exceptional writing skills, has developed our motion bank. We have probably over 100 motions that have to do with every major evidentiary issue that comes up in a case of this nature. Throughout time, children have been victims of adults. We all know that. But in the 1970s, Senator Mondale, who later became Vice President Mondale, learned how to use that fact politically. He created what is called the Mondale Act. What he learned was that if you were for increasing the budget for the Department of Defense, you'd win some votes and you'd lose some votes. If you were for increasing welfare payments, you would win some votes and you would lose some votes. But if you were against child molestation and hard on child molestation, you win votes and you win votes. Out of that political reality came the Mondale Act. The act was very well intentioned and has done a lot of good, but it has also had some extremely adverse effects. The law requires that there be mandated reporters. Doctors, ministers, psychologists, psychiatrists used to have a privilege, and if they received information from you, they would not report it. The law changed, and there was an exception written into the privileges for child abuse and child molestation. A doctor, minister, psychologist, psychiatrist, etc., is now mandated to report it. If they fail to report it, they can be criminally prosecuted. On the other hand, if they do report it, and let's say they were negligent, they do great harm, the fact of the matter is they will be given civil immunity. Civil immunity means that they cannot be sued. With the carrot and the stick being that they will be prosecuted, and the carrot being that they will be protected from civil lawsuits, people report even frivolous cases. After the passage of the Mondale Act, millions and millions of cases were reported. That is what created this hysteria about child molestation allegations and child abuse allegations. The second negative effect that came out of the Mondale Act is that enormous amounts of money were provided for district attorneys to prosecute these cases. Do you know how much was given to the defense to defend against false allegations? Nothing. Not one dime. There was a total imbalance of power because all of the funds went to the DA, special teams of DAs to prosecute, to DA expert witnesses for the prosecution, and on and on. The next thing that occurred was that we got a series of biased, one-sided laws. These have been passed every year since the Mondale Act. Also, in order to prosecute these cases, a whole field of what you would call junk science has been developed. Mental health professionals and medical professionals who have the answers to how you can find out which cases are true and which are false. Most of these theories were not based upon valid research, and this led again to easier prosecutions, but a lack of accurate prosecutions. To overcome this imbalance of power, the one-sided and biased laws, and the junk science that developed around this area, we created our own team. This team specializes in nothing but these types of cases, and by specializing, we're able to level the playing field and even turn it into our client's favor. I have several immediate warnings I want to give you that will protect you from what's to come. The first warning is a concept called the pretext phone call. The pretext phone call is when the police have a child or a relative of the child place a phone call to you. The theory behind it is that the police want to get to you while your guard is down and get you to confess to something. While the phone call is being made, it's normal practice for the police to be sitting there feeding questions written down on pieces of paper to the individual who placed the phone call. The concept is okay, and it is legal. However, it is misused. Think about getting a phone call from somebody that says, "You abused me. If you say you're sorry, I won't go to the police." Well, that puts enormous pressure on somebody who's innocent to say, "I'm sorry." In that way, it's over, and they don't have the police involved. However, when those words, quote, "I'm sorry," close quote, are later played back to a jury, it's going to sound like, "I'm guilty." What we recommend is that if you get one of these calls, just say no, nothing happened, and hang up. You do not want to spar with the cops that are on the other end of that phone call. Stay away from it and immediately call us. The second warning is that at any time you're going to be subject to a search and seizure. A warrant may be issued and your house searched, your car searched, and your computer searched. If this should happen, do not interfere with the police officers. You do not want charges of obstructing a police officer to complicate this matter. The third warning has to do with talking to the police. Most people believe that if you don't talk to the police will think you're guilty. Well, it doesn't matter what they think. What matters is the evidence. The police have been trained in a process called the Reed method of interrogation. Now, you haven't heard about that before, but let me tell you this. Back in the 1930s and 40s, the police could beat you with a rubber hose to get a confession. The Reed method of interrogation is a psychological rubber hose. You can be beaten with that psychological rubber hose, and I guarantee you that you'll confess to killing your mother, even if she's still alive. It's that powerful. That is why we tell people, do not be interviewed. Do not be subjected to an interrogation. Ask for an attorney. Assert your rights to remain silent. You should do that whether you're guilty or innocent. What comes out of those interrogations can hurt you even when you're innocent. I would like to discuss physical child abuse with you. Nothing is more heart-wrenching than photographs of a young child who has been severely physically abused. They most often show large bruises, burns, welts, or scalding that bring tears to your eyes and the urge to stop this type of torture to even the most hardened of investigators. Such disturbing photographs are also shown to legislatures to help pass new laws or to secure additional funding for social services. When the public hears of the physical child abuse, these are the very images that come to mind. In actuality, there are very few allegations of this type of serious abuse. In those rare cases of severe physical abuse, the physical evidence is often overwhelming and proves that physical child abuse has occurred. The only time that a false allegation might arise is if the true perpetrator falsely accuses someone to avoid punishment. So where are all the allegations of physical abuse coming from? For centuries in Judeo-Christian communities, parents have used physical discipline or corporal punishment as a means of teaching their children right from wrong. The Bible refers to such physical disciplines in its warning, spare the rod and spoil the child. However, shortly after World War II, this means of molding a child's moral character was challenged by a well-known pediatrician, Benjamin Spock. What he proposed was positive reinforcement and non-physical discipline as the more enlightened method of child rearing. Spock's methods were popular in more liberal circles and became the philosophical underpinning of social workers, child therapists, and child advocates. It still remains today as the foundation of any training done by state agencies. More conservative parents, however, particularly those with fundamentalist religious beliefs, have long opposed Spock's ideas. That is why the fierce conflict between these two perspectives of handling children is still not resolved in the courts. In response to the horrors of physical child abuse, many state legislatures wrestled to define what constituted such abuse in the early 1990s. Representatives were heavily lobbied by both social workers who wanted corporal punishment outlawed and by various Judeo-Christian groups who believed that it was their religious right to use corporal punishment. The end result was ambiguous statutes. Is it physical abuse if you spank your child on the back of the leg rather than on the bottom? What is age-appropriate discipline? How does one define serious physical injury? Can a red spot caused by hand spanking be a serious physical injury? These are the terms found in many state statutes, but none are properly defined. Therefore, the manner in which these statutes have become interpreted depends upon the child-rearing perspective of the people reading the statute. For example, we have found that Child Protective Services officials in California generally interpret the use of any instrument on the child as physical abuse. For decades, however, mothers spanked their child with a wooden spoon in order that the mother's hand was not associated with inflicting pain. Does the spoon used with the same force as one might use to hand spank a child constitute an instrument of abuse? In many states, Child Protective Services workers would take children away from their parents for just such discipline. Our office has counseled many Judeo-Christian oriented parents who have raised their children with love tempered with physical discipline, only to be terrified by allegations made by Child Protective Services or the police against them of child abuse. Since Child Protective Services as a group is against corporal punishment in any form, they are very liberal in interpreting corporal punishment as child abuse. They can then use their power to seize children and can request the police to make an arrest for child abuse. The police and prosecutors are not so uniform in their interpretation. Each officer, each department, and each DA's office has a different view of what is legal corporal punishment and what is not. However, police and prosecutors tend to ignore the perspective of some Judeo-Christian oriented families who feel it is their right to use corporal punishment for discipline. The freedom given to Child Protective Services workers, police officers, and prosecutors in defining corporal punishment is what most often leads to false allegations of physical child abuse. Their freedom turns into unchecked powers when combined with the unlimited resources of the DA's office and often misinformed or biased staff in judicial systems that rely upon information from people in the employment of the state. Even though the ultimate authority, the jury, will decide what is reasonable treatment of the child, it is unfair to expect families to bear the cost and trauma of a jury trial in order to establish that what they are doing is reasonable and legal. Many states' laws, as they currently stand, make it possible for agents of the state to control parents' actions, even if the parents are acting in the best interest of their child. And while Judeo-Christian groups can influence what laws are written and passed, they have little power in influencing how social workers or officers in the legal and judicial system interpret child abuse standards, and that may mean arrest, jail, and a seizure of your child should you believe that you have the right to physically punish your child in order to reinforce moral training and education. Well, as we have said, the training that most social workers, the police, and officers of the legal system receives predisposes them to believe that signs of physical contact with a child, like a bruise or a red mark, can be a sign of child abuse merely because of their concept of corporal punishment. The odds are even higher that parents will face criminal charges of physical abuse should their child be very young, nonverbal, or display a severe bruise, injury, or fracture that cannot be accounted for by the parent. Unfortunately, our office knows this too well from experience. One of the cases involved a child who was being carried in the mother's arms as she walked through the airport. She tripped and fell on the floor on top of the child. The little girl hit her head and began crying. The mother believed that the child was uninjured when the child stopped crying and the mother continued home. The mother then left the child with the father to babysit her. Several hours later, the child became seriously ill, and after being rushed to the hospital, x-rays revealed a fractured skull and a subdural hematoma. The father was immediately arrested for physical child abuse, handcuffed, and taken off to jail. He faced a maximum in that case of 8 years in prison because the radiologist, a self-proclaimed child abuse expert, reported that the force necessary for such an injury was either a fall from a third-story window or by swinging the child by her feet and smashing her head against the wall. During courtroom testimony and cross-examination, the radiologist admitted having no scientific basis for her opinion. She could not name one controlled study that supported her claim that such force as she described was necessary to cause the child's injury. Furthermore, she admitted that she had never personally witnessed a child injured by a three-story fall or being swung by the feet and having the child's head smashed against the wall. In summary, she had no scientific studies and no personal knowledge upon which to base these outrageous conclusions. Why was there a lack of science in her testimony? First of all, because she was trained to be a child advocate and had no other experience, scientific or personal, in the field. Her first response was to claim child abuse. Secondly, studying the force required to create fractures in children entails human subjects, an unthinkable kind of study in our society. Our research at our firm, however, did find studies based upon deceased animals whose bones had the same dimensions as those of children. However, the child abuse experts called by the prosecution reject the animal studies on the grounds that there are no comparison studies between animal bones versus human bones. Therefore, the validity of the controlled university research was brought into question. Our research also discovered actual human studies done in Europe, and we had to have them translated from German into English. In Germany, several studies were conducted on children who had recently died. One study focused specifically on measuring the force necessary to break limbs, another on the force necessary to fracture the skull. These studies showed that the kind of damage sustained by our client's child could have been caused by a fall of only 3 feet onto a hard floor, like that found in an airport that was approximately the height of the fall the child suffered while being held in the mother's arms, and then having her mother fall on top of her when the mother tripped. All the allegations against the father were subsequently dismissed when this scientific evidence was presented to the court. Despite the radiologist's intention to help the injured child by advocating abuse without any scientific research, she was actually harming the child by denying the child a loving parent and making it more difficult for her innocent parents to defend themselves. If her erroneous testimony had not been exposed, the child would have lost her father to prison. She would have been deprived of his love, attention, and companionship on the basis of exaggeration and personal bias. This kind of arrogance and the lack of knowledge on the part of the experts who have no data on force, whether it relates to the torque required for the spiral fracture, the angle of bending necessary to break a bone, or the impact required to fracture a skull or cause a brain injury, has no places in a court where a defendant must fight for their lives. The cause of injuries to nonverbal children is often difficult to determine. The search for evidence can be complex and time-consuming. We believe that that is the only way of distinguishing between guilt and innocence, of distinguishing between false allegations of child physical abuse and those that are true. Another very difficult form of child physical abuse is called Munchausen syndrome by proxy. This strange name came from a 1977 case where an English pediatrician, Roy Meadows, noted an article by psychiatrist Richard Asher in 1951. In 1951, Asher used the name of a legendary Baron Karl Friedrich Munchausen, the notorious 18th century German baron known for his outrageous tall tales. That's where the name came from, to describe a certain kind of psychiatric patient who sought out the attention of physicians, after physician, after physician, for more and more outlandish claims of illness or rare disease. English pediatrician Roy Meadows noted that a small percentage of mothers of their little patients brought the children into pediatricians and hospitals all too often. Meadows noted that these parents, almost always mothers, consistently insisted their children were ill. He also noted that these parents seemed to enjoy the special attention numerous medical personnel had to give to the parents' ever more exaggerated claims. In the severe cases, Meadows noticed that the parents were so intent upon obtaining the attention of medical personnel, they actually caused their child's injury by diet, poisoning, or other means to become ill. Today, the contributors to the American Psychiatric Diagnostic and Statistical Manual call this kind of process factitious illness, and they are studying Munchausen syndrome by proxy for inclusion in the manual. Modern research notes that this constellation known as Munchausen syndrome by proxy involves the intentional production of physical or psychological signs and symptoms in a person under the care of the individual. Modern research suggests that the motivation of the individual is to assume the sick role and the attention of the medical personnel that comes with it by proxy or through the child. Although these cases are rare, our office is involved in the defense of parents accused of this disorder. These cases are quite expensive because they require both medical and psychological experts. If an actual physical illness exists in the child, was it caused by the accused parent? If no physical evidence can be found in the investigation, was the examination reliable? These are just some of the questions our team works to answer with our experts and our research data.
1974 until I retired, I was a detective in the Riverside County Sheriff's Department assigned to the Crimes Against Pattern Analysis Unit, the Law Enforcement Intelligence Unit, and the Crimes Against Persons Unit. Allegations of child sexual abuse and child physical abuse are handled by the Crimes Against Persons Unit. During this time, the country was rocked by sensational cases such as the McMartin preschool case and the Bakersfield sex ring cases, and many more. These cases were based upon investigations that went out of control. Fortunately, we didn't have problems like this in Riverside County. Certainly, we had our share of accusations. So how did we avoid these types of problems created by investigations that went out of control? Command instructed us to do investigations as if we were defense investigators. That's right. I was told to conduct my investigations as if I was the defense investigator. If you're searching for the truth, you must be as concerned about those that are innocent as you are about those who are guilty. This attitude helped us avoid approaching a case with a single hypothesis and motivated us to explore other possibilities of how something could have occurred. Today, as I do investigations for the defense, I'm encouraged by law firms I work for to conduct an investigation if I were the police. Why? Because good defense attorneys are concerned with what is out there and what facts a good investigation will uncover. Good defense counsel want to know what is out there that can affect their case, and they want to know it as soon as possible. Today I want to talk to you about what a competent investigation entails, whether that investigation is conducted by law enforcement or by the defense. The information I'm going to give you today comes from, in large part, the presentation that I give to law enforcement when I do training programs for POST, Police Officer Standard of Training. It doesn't matter what the audience is made up of, law enforcement professionals or defense investigators, the message is the same. Search for the truth. The investigator is supposed to be the finder of fact in the search for the truth. It's important that the investigator assist the attorney at trial, whether that attorney is the defense attorney or that attorney is the district attorney that the investigator is assisting. The assistance is based upon the investigator's search for the truth, and in the search for the truth, reliability is the key. For us, reliability means, 1, are there sufficient corroborating facts supporting a conclusion? 2, will it hold up to scrutiny? 3, will it hold up over time? It is important to understand that when any investigator looks at a case, they want to be concerned with the reliability of the information contained in the case. Bias affects that reliability. One of the most important kinds of bias an investigator needs to watch for is called confirmatory bias. In its worst form, this means driving towards a specific conclusion, no matter what the evidence may be. Confirmatory bias is widespread. It can be overcome only with specialized training. It is especially important to learn to ask the right questions. We must guard against focusing only on "he did it" or "he didn't do it" kinds of information. We can guard against confirmatory bias by trying to look for the whole picture. Number 1, who made the initial allegation? Number 2, what were the circumstances of the initial allegation? Number 3, who stands to gain by the allegation, and so on. This is the groundwork an investigator will lay down to help guard against confirmatory bias. We must also consider coercion. This can mean manipulation by someone with something to gain by the allegation. It can mean an overzealous interviewer mishearing a child, or worse, it can mean covert threats, which almost any investigator will work to uncover. Investigators should carefully review audio and videotape interviews, whether they be of witnesses, or the victim, or the suspect. I teach that good investigators must interview the suspect concerning the circumstances and his state of mind during any admission or confessions he may or may not have made, either in the interrogation arena or in the pretext arena. The pretext arena refers to pretext telephone calls made by the alleged victim to the suspect that is recorded by the police investigators. An investigator must carefully review the circumstances and the state of mind of the defendant in both of these areas to uncover coercion, misinterpretation, or misunderstandings. We find that chronologies and witness lists are of great value. It is the client and the investigator that put the chronology and the relevant facts together for the attorney. This helps create a context for events and serves to guide the investigation and the trial preparation. This is of great importance because absent the context of how something occurs, it's very difficult to form an accurate picture. Another important factor in any good investigation is to develop evidence on the credibility of all witnesses. that they have any motives to lie, they have any motives to get back at someone. We also take a look at issues of source monitoring, and this generally means to the source attribution and source misattribution. Dr. Larandos tells us more about this in the seminar on suggestibility. Let me just say that source monitoring refers to the process of identifying the origin of one's knowledge of events. Maybe someone has a memory, but did that memory come from an actual event, or from just thinking about that event, or from the event being suggested to them? My friend Dr. Elizabeth Loftus has done a great deal of important research in this arena, and a great deal of that research is presented in the seminar on suggestibility. It is also important to remember that as people we tend to look for things that support our own personal point of view. As investigators, we must look at prior interviews that have occurred for indications of such bias. These indications are sometimes apparent because of the complete lack of prior interviews or any attempt to think about or search for any alternative hypothesis. Remember I talked about guarding against focusing on only he did it kinds of information? It's crucial in a good investigation to determine whether interviews looked at any alternative hypothesis other than he did it. We look for, as we say in psychology, the pursuit of alternative hypotheses. Are there other possibilities of how this event could have occurred? In general, we try in our interview process to examine other possibilities. The investigator will also consider confessions and ask, do you have any coerced confessions? Professor Leo has spoken a good deal about this. I would add that the objective investigator will not take a confession at face value, but will investigate whether the suspect was scared, or look into the possibility that maybe they said what they said because they thought it would help them with less jeopardy. We must also look for factual disclosure that only a person that is guilty would be aware of. These are but a few of the important issues for psychologists and good investigators to answer. Let me also say that we must carefully look at the medical reports. Medical reports may or may not confirm that which is. We know that a good investigator will investigate issues of opportunity, motivation, and sexual knowledge. It's how an investigator looks into these important concerns that I want to talk about now. When conducting interviews, the skilled investigator will be concerned with the reliability of the information provided. There is significant research regarding the issues of memories and malleability of memory. One of these important malleability issues is coercion. An investigator should work to determine if coercion was used with any witness, and if so, as a result, the individual may assent or accommodate and give the story that they gave to minimize the possible negative outcome. The concerned investigator will also work to determine whether the information provided by any of the witnesses or victim was based in any way on the suggestibility of that person. Also, the investigator should look at the possibility of implantation of non-events. Analyzing interviews, the objective investigator will look at issues of
We have found research that was performed on animals, and we have also found research that was performed on children who were recently deceased. This research came from Europe and had not been translated into English or published in U.S. periodicals. We maintain a library on this type of empirical but controversial research. When we have shown this research to our experts, they are emotionally disturbed that such research exists, but they soon realize its value in finding the truth. Here's a short clip from one of our videos used to train lawyers and judges on this issue.
The first study we found was from a hospital in Sweden. The researchers had taken dog bones from euthanized dogs and placed them under torsion. That's the twisting motion, but without enough torque to cause the bone to break. Microphones were hooked to the bones, and they were able to hear that micro-cracking was occurring. Performing repeated small torsions finally led to the breaking of the bone. This would be analogous to metal fatigue in an airplane. This phenomenon was not known to have occurred prior to this study. The second study was from Sweden, and it showed the ability of child's legs to stand up to torsion forces increased dramatically during the first year of life. Therefore, the younger the child, the easier it is to break a child's leg by torsion. A third study was located in England, which was performed on the bones of euthanized rabbits. That's where this photo came from. This study is believed to simulate closely the amount of torque necessary to create spiral fractures in children's legs. It was found that the amount of torque necessary to cause the breaking of the bone with one torque action is similar to the amount of torque that is generated when an adult holds a 10-pound weight in his hand and rests his elbow at the edge of a table. Let me demonstrate. If you put a 10-pound weight in your hand, placed your elbow, it would create a torque in your elbow joint. That is the amount of torque that it would take to break a femur with one motion of a young child. A fourth study from Germany has never been translated before into English. Our firm translated it. This study was actually conducted on the bones of young children who had recently died. This is a diagram of the mechanism that was used for that test. It was able to establish the amount of force necessary to break bones.
I'd like to talk a little bit about the philosophy of our group. In cases such as these, the prosecution has a 98.5% win rate throughout the country. The defense wins at about 1.5%. Now, that's not our win rate. We have a 40 to 60 times higher win rate. Why is that? Well, a public defender handles 350 cases a year. Now, with 220 workdays in a year, you can imagine how much time they spend on an individual case. Now, serious felonies get less than an hour of time from the public defender because of this incredible workload. Now, for private attorneys, they typically handle 80 to 120 cases a year. Why? Because they're trying to pay for those yellow page ads. They take a lot of cases in and they plead as many of them as possible. They get a retainer and then they bargain with you and with the prosecution as quickly as possible so they can move on to their next retainer. You cannot evaluate a case until it is prepared for trial. Let me give you an example. I had a case of a grandfather who was charged with a molestation, and the prosecution thought he was guilty. Our investigator had met a Catholic priest, and he believed that the priest had information about the case, but the priest wasn't talking. Our investigator kept going back over and over and over again. On the fourth day of trial, the priest finally broke and turned over letters that had been written by our client's granddaughter. And in those letters, she said that she had sex with over 40 men in the congregation. Previously, she had been saying that she was a virgin and that the only person that she had been involved with was her grandfather. She was caught lying and making up stories. The charges were dropped on the fourth day of trial. This is the kind of tenacity we bring to continuing litigation. It is also an example of why you cannot evaluate a case until it is completely prepared, until you have all of the answers. This is the kind of tenacity that we bring to continuing litigation. We believe that the preparation must be completed before any decisions can be made about the case. We handle only 8 to 12 cases a year, and perhaps a couple of small cases that we have a special interest in. Our preparation begins on day one. We scan in all the documents, we index all the documents, we capture all audio tapes, we capture all videotapes, and they are put on our computers electronically. We prepare transcripts of all of these tapes. We prepare clips for presentation during trial and during the closing. We have a jobs list where we make a list of everything that we are going to do and the job assignments for every other member of the team that is going to work on the case. We have a chronology that we develop, which we primarily get from you, and we update consistently, telling us absolutely everything that happened in chronological order. We make a witness list while we are receiving these documents so that we can contact every person that is mentioned in any report that may be of any value to us. The reason for this? You can be reading on page 65 and it mentions a janitor who is not involved in the case. And on page 650, you can read about the janitor and now he's become a key witness. How do you go back and find that address that was on page 65? You can't. So we keep track of all addresses as we see them, as we run across them, along with phone numbers and other contact information. We make an outline of every witness's testimony. We do not wait to a week before trial. We begin the very first reading of the case making these outlines. All of these documents, a jobs list, a chronology, a witness list, and outlines for witnesses are all prepared at the same time. We call it multitasking. It's extensive preparation that wins cases. Now, we can teach you everything that we're going to do on your case so that you are an equal partner in the preparation of your case. And we insist that you remain so. Remember, it's your case. Now, the prosecuting attorney will make offers whether or not you want them to. Our job is to make sure that you make an educated and informed decision on whether to accept any of these offers or whether to go to trial. Remember, there is hope. Many clients ask about coverage in their area of California. Simply put, we handle cases all over California. Our team members appear in every California county and have done so for years. We keep connected to our office electronically over the internet through PC Anywhere and other computer programs. It's easy to get around the state of California. With the use of Southwest Airlines and United Airlines, we are linked to all of California. Besides being linked to our own data files and research, our experts, our investigators, and all members of our team are also connected over the internet. This allows our team members to have instant access to all the materials that they need, no matter where they appear in the state of California. Sometimes people will say, well, gee, there's an attorney here locally who says he knows the judge, wink, wink. Well, I've never seen a judge or a DA give away the case because of friendship. But what I have seen over and over again is that when we appear in the courts, we're prepared, we have our investigations done, we have our motions done, and we know what we're doing. Within the first day, the judges have gotten to like us because they recognize quality presentations, and that's what they're interested in, and that is what they respect. We know that you are located in another state. You need to know if our team can come into your state and represent you. Of course we can. Our team members practice in every state on a case-by-case basis. This is a procedure called pro hac vice. This means that an out-of-state attorney presents his or her credentials to the local trial judge and requests to be allowed to practice just like a local attorney in your area for just your case. In fact, the U.S. Supreme Court has encouraged this practice. Why? So that people can get an expert in the field that they need, because many times these experts are not available locally. When we practice outside of California, we always work with a local attorney. This helps us to make sure that all local rules for your state and your county are followed. We have in our office the law of all 50 states, federal and military, so we are able to represent you in any of these forums. Now that you know the politics and seriousness of the offense that you are accused of, we would like to meet with you. We will try to stop the charges from being filed, if they have not already been filed, by contacting the police and the district attorney. Maybe, if they are presented another side of the case, they won't even file. We will protect the evidence for your defense. This must be done immediately. Before you meet with us, it would be important that you prepare a chronology of events and set out everything that has happened and the time order in which it happened. Clearly mark that attorney-client privilege at the top of the document so that if it is intercepted in any way, it is protected. We also need to know about your background and any prior allegations that have been made against you. You can survive these charges. We believe that the survival is based upon preparation, preparation, preparation. Defending against allegations of this type can be costly. However, you only get one trial. You only get one chance. We cannot guarantee the outcome. Those attorneys who do that are lying to you. What we can do is make sure that everything that can be done will be done. In this way, we maximize your chances of the best outcome in your case. We are known for being a big case firm. We don't go to court with 10 files under our arms, as you will see with many other attorneys. We only take cases where the stakes are very high. We take cases that require extensive preparation. There is a large learning curve for you to go through to get prepared for our meeting. We want you to watch this video before we meet and discuss your case. The meeting will be more meaningful if you do this. Now, I would like to introduce you to the team members. I'm Patrick Clancy. I've been practicing law since 1974. I'm what is called a certified criminal law specialist. In the state of California, an attorney is not allowed to call himself a specialist unless you're certified by the California State Bar. Basically, what that means is I did so many trials, so many appeals, so many writs, obtained recommendations from judges, recommendations from district attorneys, and that then gives you the honor of taking a second bar exam, much harder than the first. The first bar exam had 14 subject matters. The criminal law specialist exam has 1 subject matter. My involvement in cases of false allegations of child abuse and child molestation predates the McMartin case, the infamous case in Los Angeles. Our law firm, as far as I am aware, is the only firm that deals exclusively with issues of. However, we wanted to have our motions at the trial level to be of that top quality. They are so good that our motions are now copied throughout the state and are plagiarized all the time. Julie has a lot to do with the building of our motion banks. For those who don't know, motions are documents filed with the court that says that the prosecution has some evidence that should not come in, and here's why. And here's all the law and the cases having to do with that issue. Oh, and by the way, we have some evidence that should come in. Here's the case law and statutes which explain why it should be allowed in. Julie, with her exceptional writing skills, has developed our motion bank. We have probably over 100 motions that have to do with every major evidentiary issue that comes up in a case of this nature. Throughout time, children have been victims of adults. We all know that. But in the 1970s, Senator Mondale, who later became Vice President Mondale, learned how to use that fact politically. He created what is called the Mondale Act. What he learned was that if you were for increasing the budget for the Department of Defense, you'd win some votes and you'd lose some votes. If you were for increasing welfare payments, you would win some votes and you would lose some votes. But if you were against child molestation and hard on child molestation, you win votes and you win votes. Out of that political reality came Colorado, and every time he wanted visitation, he got accused of another act of molestation. She was living in this rich neighborhood with a very well-to-do doctor and felt that she could just throw lightning bolts down on her ex-husband every time he went for any visitation. One day, she woke up in her nice ritzy house in Denver and found that there was a gentleman named Harvey Shapiro going around door to door to all of her neighbors, finding out about the sex and drug habits of the doctor's new wife, which just happened to be part of the defense. The DA the next day got a phone call from the ex-wife telling the DA that they didn't want to go any further with the case, and the case ended up being dismissed. Harvey knows how to understand people and how to use that to our benefit. Another member of our team is Julie Schumer. Julie is a certified appellate law specialist. Again, the same thing as I said about criminal law specialists. She had to take a second bar examination after handling so many appeals, so many writs, recommendations from judges, and from her peers. Julie is highly unique. If you put Julie in front of a jury, I think she would pass out. She just does not want to be a public speaker in that sense. She's a Phi Beta Kappa English major from UCLA. She's a writer. She's a researcher. Normally, you would never meet someone like her unless you had lost your case and were up before the Supreme Court of their Crimes Against Persons Unit, which is charged with investigating child molestation cases. The training that he has received is enormous. His resume is about 24 pages long. I think he's attended every major seminar ever given, and he's taught at most of these seminars. One of the things that I really like to point out is there is a gentleman named Dr. Stephen Ceci, who is one of the top suggestibility researchers in the world. Stephen Ceci does not like to testify. So what he does is he trains approximately 30 people a year by invitation only at Cornell. Harvey Shapiro was the only investigator that's ever been asked to come and train there. Since then, he's actually given training seminars at Cornell. In 1985, there was only about one line in the police training manual. It's called POST, Police Officers Standard of Training, having to do with false allegations. Several years ago, POST came out with a new training manual. Harvey Shapiro was the only defense investigator who was asked to be a consultant on this training manual. He's an expert in suggestibility research and one of the top investigators for the defense anywhere. Besides being a good investigator, he understands people. In representing you, he will use the same tactics that the police use. Let me give you an example. We had a client whose wife had divorced him, moved to Colorado with false allegations in abuse cases. Dr. Larandos is a major member of our team. He's a psychologist and an expert witness. I met him decades ago on the East Coast when we were both attending training seminars together and giving them together. Over the years, it developed to where he was testifying in my cases as an expert witness. But since he is an expert, a psychologist and a lawyer, it eventually evolved that we started practicing law together. He's known nationally because of the work that he's published. He published cross-examining experts in the behavioral sciences. And he also published bench book in the behavioral sciences, psychiatry, psychology, and social work. What these two books do is train lawyers how to cross-examine experts. It also trains judges. That's what benchbook means. In what you look for in terms of scientific reliability, with so-called experts who are testifying in the behavioral sciences. Dr. Larandos heads up the science department of our team. He's been fighting junk science's use by the prosecution in abuse cases for decades. His knowledge and research are invaluable to our team and will be invaluable to you. The next person is our investigator. He is probably one of the central figures in our team because I believe the cases are won or lost based upon investigation. Harvey Shapiro was a member of the Riverside Sheriff's Department and was the head